The story of Pierson v. Ray begins in 1961, a time when the American South was still gripped by institutionalized segregation and racial injustice. Against this backdrop, 15 Episcopal clergymen, both black and white, embarked on a prayer pilgrimage. From New Orleans to Detroit, their goal was not simply spiritual reflection. It was civil disobedience with a higher purpose, to confront the immorality and illegality of racial segregation. As part of this pilgrimage, the clergymen made a deliberate decision to stop at the segregated interstate bus terminal in Jackson, Mississippi. Their intention was to peacefully enter and use the white-only waiting room and adjoining restaurant facilities, knowing full well this act would likely lead to arrest. They had prearranged legal representation and bail, expecting confrontation as part of their non-violent protest. Their expectations were quickly fulfilled. Upon entering the segregated area, the ministers were met by Jackson police officers Ray, Griffith, and Nichols, who had been tipped off and were waiting. The officers ordered the clergymen to move on. When the ministers politely refused and stated their intent to eat, they were arrested on the spot. The charge, violating Section 2008 E7.5 of the Mississippi Code. This statute criminalized congregating in a public space under conditions that might lead to a breach of the peace and refusing to disperse when instructed by law enforcement. Although the ministers' entry into the terminal was peaceful and non-disruptive, the justification for arrest hinged on whether a threatening crowd had formed around them. According to police testimony, a group of 25 to 30 people had followed the clergymen and made threatening gestures or mumbled in disapproval, though there were no acts of violence. Importantly, the police took no action against this alleged crowd. Instead, they placed the burden of the potential disturbance on the ministers themselves. The ministers, on the other hand, consistently denied the presence of any threatening crowd. They contended that they acted respectfully, caused no disturbance, and were met only by hostility from law enforcement. After their arrest, the clergymen waived their right to a jury trial. They were tried by Municipal Police Justice Spencer, one of the respondents in the eventual Pierson v. Ray case. The result was swift and severe. Each minister received the maximum penalty, 4 months in jail and $200 fine. However, this was not the end of the road. On appeal, one of the ministers, Reverend Jones, was granted a new trial de novo in the county court. During this proceeding, the court directed a verdict in Jones's favor, effectively invalidating the convictions. As a result, the charges against the remaining ministers were dismissed as well. These events set the factual foundation for what would become a defining case in the doctrine of official immunity. The ministers, having been wrongfully arrested and convicted under a dubious public order law, would turn to 42 U.S.C. Section 1983 to seek redress, but the courts, rather than focusing solely on the facts, would grapple with a deeper legal question. Could judges and police officers be held personally liable for unconstitutional actions taken under color of state law?